if you could call the roll.
You have a quorum, Mr. Chair?
Okay, thank you. We have a sign-up sheet, and it looks like Senator Lewis, you're first in the breach.
Yes, sir. Thank you, Mr. Chairman. Senate Bill 695, Mr. Chairman, members of the committee.
Committee will bring their attention to 695. Floor is yours, sir.
Mr. Chairman, members of the committee, this is democracy in action. This came to me from a constituent who, in the process of exploring a business idea that he had, found out there was no ABC license which would allow him to do what he wanted to do. Specifically, what he had in mind was partnering with local breweries to create a subscription service for consumers to receive a monthly shipment of 12 beers to their home. He called the ABC office and found out they did not have a license for that. If he was from out of state and wanted to ship to consumers into Virginia, there was no problem. They had a license for that. But as a Virginian, he couldn't do it. So this is an identical license. This legislation provides for an identical license for internet wine retailers within the state. So this would expand the license to the beer folks. Out-of-state companies and businesses can already do this and ship into Virginia. It's just Virginians who want to ship within the state who aren't able to currently do so. There is a limit of 2 cases per person per month. And believe we've run this by the ABC folks and also the beer wholesalers, and there doesn't seem to be any heartburn generated by it, Mr. Chairman.
Thanks, Senator Lewis. All right, well, let's hear from some of those folks that are for this bill. We're going to try to stay on a tight timer today, so we'll go ahead and start that if folks in favor of the bill.
Mr. Chairman, Phil Boykin, Virginia Beer Wholesalers Association. We thank Senator Lewis for putting this forward, and we support the legislation.
Okay. Anyone else? Anyone against the bill? Okay.
Second.
We have a motion to report the bill. It's been properly seconded. To all those in favor of supporting this good bill, vote aye.
Thank you, Mr. Chairman. Thank the committee.
Ayes 14, no 0.
I pushed.
Can you clear the board, please? All right, let's try it again. Okay.
Ayes 15, no 0.
Ayes 15, no 0. Okay. Adam Eben, Senator Eben here? He's not here. Okay. Let's get started with a couple of admin things real quick. Senator D-Staff has Senate Bill 773. He has a motion for his bill. It's a ratio bill to pass that by for the year to keep it in the breast of the committee. I'd entertain a motion for that. It's been moved and seconded.
Ayes 15, no 0.
Okay, ayes 15, no 0. The committee heard Senate Bill 506, which is Senator Carrico's bill that we heard from Pastor Mike from Southwest Virginia. I heard from many of you on this committee that thought they wanted to hear that bill again, and I know Senator Chafin has an amendment to that bill to try to give them the opportunity in Southwest to have a shot at doing what they were trying to do. The committee heard multiple testimonies about where they were and what they were doing. One of the reservations was, once they're in that program, how can they get out? So Senator Chafin has an amendment to the bill that would put a sunset clause till 2021 on that original bill. But Senator McPike, do you have a motion?
Mr. Chairman, I move that we reconsider the vote which we PBI'd the bill.
Second. All right, the motion is to reconsider the vote in which we PBI'd. Okay. All right, so 506 is now before us. David, do you want to read what that amendment would be on Senator Carrico's bill 506?
Mr. Chair, it would be one line amendment, essentially inserting 2 final enactment clauses. So after line 89, insert 2, that the provisions of this act shall become effective on July 1st, 2019, and 3, that the provisions of this act shall expire on July 1st, 2021. So it starts 2 years from now, and it expires 2 years after that.
Okay, the amendment's been moved and seconded. All those in favor say aye. Aye. Any opposed? Okay, that bill's before us. Go ahead, Frank. Okay, it's been moved and seconded to report the bill as amended. You want to call the roll?
Ayes 15, no zero.
Ayes 15, no zero. That bill is out of here. Okay, let me go to my list. Okay, committee will call Senator Favoli. Ready to do your bill?
I am, sir.
Okay. Committee will bring its attention to Senate Bill 61. We had heard the bill here, but I know some members had some questions about the percentage of alcohol, and I think Senator Favola might have an amendment to that as well. So committee will bring its attention to 61.
Thank you, Mr. Chairman. There are some, there is an amendment before you, so I would ask that you go ahead and adopt it.
Okay, let's get that out, David.
I can speak to the amendment, Mr. Chairman.
Go ahead.
On line 135, it does add a sentence that says, after the word volume, any alcohol contained in such confectionery shall not be in liquid form at the time such confectionery is sold. We felt that this line amendment would address some of the questions that had come up. And then, of course, we do have a statement after line 387, which says that the Alcohol Beverage Control Board will promulgate regulations, and we also mention that these regulations not only would define the term confectionery, but would probably have requirements such as labeling and anything else that might be appropriate.
So Senator Favola, real quick,
Do you want me to go over the bill
what
again?
what your line amendment does to the concentration of alcohol in the item at this point?
It does not change the concentration of alcohol. My bill still would allow a confectionery license for items prepared and sold on site but consumed off site, and those items could contain up to 0.5% to 5% of alcohol. But what my line item does is it ensures that the alcohol is not in liquid form. So you wouldn't have a chocolate candy, say, with a liquid rum in the middle, like a
Right.
rum ball.
Got it.
So everything would have to be baked. Mr. Chairman, I know that other questions have come up, and we did a little bit of research. I should allow the,
Well, let me see
Small
if any
business.
members have a question for you real quick. Do any members of the committee have a question for Senator Favola? Senator DeStaff, then Senator Black.
Senator Favola, I've got,
Yes.
Mr. Chairman, Senator Favola, I've got one quick question. So I want to make sure I understand this right. So as I'm doing like buttercream to put on the top of a chocolate chip cupcake, if I mix 10% alcohol into that, so that would be the equivalent of a shot, and put that as icing on top of a cupcake, you know, the buttercream icing that we all like. You can do it with peanut butter buttercream on a chocolate. Oh, man, it's great. Anyways, I digress a little bit. Anyways, so what you're saying, that the icing's not cooked, so the alcohol would still be there at, say, 10% or the equivalent of 2 beers, or 5%, the equivalent of 1 beer or a glass of wine or a shot on top of that cupcake.
that's not, no, nothing could contain more than 5%. I mean, that would be the maximum alcohol content of any confectionery defined under this bill.
So then it would only equal,
Senator
Mr.
Easton.
Chairman, if I may, so then it would only equal the equivalent of 1 shot on top of a cupcake.
Well, I can go over what the USDA has to say about alcohol and its consumption when you're talking about food. Usually a large portion of alcohol is cooked off when you put the alcohol into a recipe early on. And just vanilla extract, for example, actually has some alcohol content in it, which is interesting. And it could be the same as rum or vodka. There would be labeling requirements so it would be, individuals would know that some alcohol was contained in it. I don't know specifically, I'm looking down about the icing example that you gave me. I do know that ABC would be responsible for doing whatever monitoring would be needed, and they would be measuring the alcohol content after the product is cooked or prepared and ready for consumption. And at that point, it would have to be less than 5%.
Mr. Chair,
Senator DeStefano.
Senator Fulda, if I may. So normally you put the buttercream or the icing on afterwards, so the alcohol would not be cooked out because you don't cook icing or you don't cook buttercream.
Would the alcohol be in liquid form?
No, actually, the alcohol is integrated into the buttercream, so it would be that of a solid form.
I would like to, I would ask Travis Hill to come up and answer your question, because your question is, would that be covered under this?
My question is, it seems to me that that would be 5% because buttercream is butter, it's cream cheese, sugar, and if you put a shot or two of alcohol in that buttercream that you're going to put on top of that chocolate cupcake, then that's going to be the equivalent of a shot of whiskey or a glass of wine or a beer, 5%.
Step on up, Travis. You got any thoughts about that?
I'm way out of my league. We're talking about
Sounds
baking
good.
and buttercream right now. Mr. Chairman, Travis Hill with Virginia ABC. I think that the gist of the question is, how are we going to figure out what the alcohol content would be or regulate that? ABC wouldn't measure that. What we've done in the past with these products that have been deemed to be below 0.5% alcohol, they will submit it to a testing lab where they will determine what the ABV is. They'll give us the recipe, and that's where we'll say, okay, you're below that percentage. So I would assume the same thing would happen here. We would expect the producer to show us the recipe and show us that certificate from the lab that says it was prepared according to these steps. The ABV of this product is 4%. We would approve it. If it's over that, we would say we can't approve this.
Okay, Mr. Chair.
Senator DeStefano.
Travis. So basically, when you come to the frosting or the, in this instance would be, we'll call it a peanut butter buttercream on top of a chocolate cupcake because that's just wonderful. And if you had that and you mixed it in, you could easily do 5% alcohol or more, but based on the bill, it would be not allowed higher than 5%, which would be the equivalent of one beer, one glass of wine, or one shot. And the issue I have with that is, you know, a chocolate cupcake with peanut butter buttercream or whatever kind of buttercream you want to put on top of that would be pretty enticing to just about anybody. And that's my concern.
Mr. Chairman, when you're making
Fuller.
that, since I make a lot of icing myself, when you're making that icing, you're preparing a big batch and you're only putting a little bit on a cupcake. So I think this is measured by volume, so it would be that one cupcake. I can't imagine that the whole 5% alcohol would be lapped on one cupcake. So,
And Mr. Chair, if I
Senator
may,
DeStefano.
Senator Favola, I have a daughter who's a pretty good baker. And when she was in college, they used Everclear, and they would mix it in with a frosting that they put on cakes and cupcakes and things of that nature. They also did these things that I may or may not have ever seen in my life called Jell-O shooters. But they got pretty creative with this. And I can tell you that the equivalent of one shot on the equivalent of about a quarter of a cup of buttercream, which is what you would normally put on one cupcake, is the equivalent of a shot, and it can be greater depending on what alcohol you're mixing in with that. Now, my children are pretty creative at times, and I had never thought about doing something like this. I'm not referring to the Jell-O shooters. I'm specifically referring to mixing alcohol in buttercream. But I've seen some pretty creative things out there like this. So if we're talking about, and again, so I know it's possible. I know it's extremely possible because I mistakenly took a bite of one of these cupcakes, and it tasted pretty much like a martini, peanut butter martini. But on the other side, I just want to make sure that we understand that the alcohol is not getting cooked off on this. You can have it pretty strong on top of there. One shot is what your bill proposes, but I've seen it much stronger than that. So it's not hard to do. And if you'd like, I'm happy to call her and have her make up a little batch, and I'm happy to bring it up on Monday.
I'm sure it's capable.
All right.
She's quite
With that,
capable.
Mr. Chair,
May
I'm finished, and I
okay.
just
All right.
That truly does address the concerns, and I don't want to mislead the committee, I don't want to mislead anyone. But what I do want to say is that it's very possible, it's very probable, and it's not hard to do. Thank you very much.
Except it has to be within that 5%, which is what my bill would require. I would like the Baker, who
Okay.
is really the
Well,
cause
let's see,
behind
do
my
any other
bill.
members have a question for Senator Favola real quick?
Yes, Mr. Chairman.
Senator Sproul?
I'm trying to find out why you want to have some alcohol on top of cake. This is to make more money, and what's the reason for doing it?
All right, so that might be a good question for the requester of the bill.
Yes, sir.
Come on up, Mr. Bolin.
You understand my question, sir? I'm
Yes,
trying to find out if it's just to make more money to get kids started on drinking.
No.
What's the reason for doing it?
So, Chairman, Senators, do you mind if I address the first question first? Or
Sure,
what would you
go
prefer?
right ahead.
And this is my wife, Rachel. She does all the baking. I've been helping her with the legislative process through all this. To your question, you're absolutely correct that there are people that can do extreme things with buttercream, with Jell-O shots, and we do not believe that this bill would allow that. When we're talking about the cupcakes that she makes, when she makes a batch of 24 cupcakes, she puts approximately 5 to 7 tablespoons of a rum, a vodka, a lower ABV, because we have to make sure that once it's mixed and prepared and put on the volume of a cupcake, that it stays below that 5% limit. So when she uses that and you do the average and you make the scientific measurement, the folks that would put Everclear in a buttercream, you can't do that and get under 5% ABV. There are folks, I know ABC has enforced some folks that have made higher ABV cupcakes in the past year and gotten them to conform their recipes to the current 0.5% limit. So I think those extreme circumstances would certainly be in that 10%, 15%, 20% range. The example we like to give is vanilla extract is approximately 70 proof, 35% alcohol, which is the exact same as rum and vodka. The stuff that she uses, Frangelico, or the one she made last night, that's even a lower ABV. So yes, you may only use 1 or 2 tablespoons of vanilla extract. She's extending that to 5 to 7 tablespoons. But you have to remember it's by volume. So the example we like to give is to equate to a pint of beer. If we use the example of ice cream, you've got to consume 2 pints of ice cream to equate to 1 light beer. In the instance of her cupcakes, you know, if you think about a pint glass that's a light beer, you've got to cram 4 or 5 cupcakes in that glass. So if you were to eat 4 or 5 of these cupcakes, is it equivalent to a single light beer? Yes, that is an accurate statement. You probably have to consume a couple dozen cupcakes to equate to the 2 or 3 beers that somebody might get buzzed off of. So hopefully that at least gives you a little bit more context on your question, but your concerns are certainly accurate.
Okay, can you address Senator Sproul's?
Absolutely. So in terms of why we're looking to do this, it's a huge trend. It's a huge trend across the U.S. The Virginia beer industry, wine industry, distillery industry is booming. We're really looking, she started this all to feature local breweries, local wineries, to just build those partnerships. Folks like, something to enhance their experience when they go to a winery or a brewery. A lot of people do this at home. We're here to represent a lot of other businesses. One of our friends we've met in Richmond makes a wine jelly. It's an old family recipe that folks put on their bread and toast in the morning when they're going to the winery. It's a 3% ABV wine jelly. So it's more about just enhancing the experience when we're there. We really want to make sure the labeling requirements over 21, card folks, keep it under 5% alcohol. We found out the hard way. We wanted to do this the right way, the legal way when we started. And we found out that there were enforcement problems, there wasn't a license, and we just want to do this the legal way, the right way, make it clear to everybody that wants to do this, that there is a way to do it and a way to do it appropriately, that it can be, consumed by everybody.
Thank you. Anybody else have a question?
Mr. Chairman.
Senator Cosgrove and Senator Black.
Sir, you look really familiar.
Yes.
Yeah.
I look a lot like my father.
Oh, that's it. Yeah, thanks.
Yeah.
Senator Black.
Mr. Chairman, so are these sold through the ABC stores?
They are not. So we wanted to take a very small step here because there are some complexities when you talk about being sold through distribution, wholesale, retail, all that. This is all about selling direct to a consumer. We had a lot of conversations with ABC, a number of other stakeholders, the restaurants, gotten a lot of advice and help through the process. This only would allow us to sell it from our place of business to be consumed off-site at our place of business. So it's a very narrow scope right now. It doesn't broach into retail or
And Mr.
ABC
Chairman,
stores.
Senator Black.
And as I understand, you won't sell it to anyone who is under 21?
Absolutely not. We never have, even today, even though it's legal in the Commonwealth to sell under 0.5% to anyone. We've made it very strict that we only sell to those over 21.
Mr. Chairman?
Senator Black.
So these will, they go out to homes, and it just seems, candy is awfully appealing to children, and so you have candies laying around. It's a little different if you've got a whiskey bottle up somewhere. The kids are probably not going to go after that, but if they've got candies and cupcakes and things like that, there's really not much control over that, is there?
No, I mean, I think that's why we want to make sure there are strict labeling requirements, that people know what they're purchasing. I know in just speaking to some senators and delegates that we've met with, the important thing to them is just making sure it's labeled properly. Make sure it's clearly labeled that it's for adults, it's not for children, that folks know what they're purchasing. We obviously can't police folks' homes, but it's a valid concern. But we hope it's mitigated by the labeling requirements and the purchase requirements.
Mr. Chairman,
Okay. Senator Wagner.
have we adopted the amendments?
No.
Mr. Chairman, I move we adopt the amendments.
All right. All those in favor of adopting the amendment, say aye. Aye. Any opposed? Okay. The amendment's been adopted before us.
Mr. Chairman, I move we report the bill as amended.
Second.
All right. It's been moved and seconded to report the bill as amended. Clerk, call the roll.
Ayes 11, noes 4.
Ayes 11, noes 4. Senator Fuller, that's, you're good to go.
Thank you,
I
Mr.
see
Chairman.
Senator Evan here. If you can step on up, we're going to take Senator Evan's bills up. Let me just remind the committee that we have a really tight docket, and I'd like to belabor every issue that we have, but we do have to move pretty quickly through this thing. So if you all can help me with some very pointed questions, if you have those. I'm not trying to dissuade people from speaking for or against the bill, but I would like to get the docket completed today.
Thank you, sir. Mr. Chairman, members of the committee, the first bill is Senate Bill 588, which has some line amendments.
Okay, Senate will bring their attention to 588. Dave, do you have the line amendments?
Yeah, Mr. Chair, there are two line amendments. The first is on line 77 after 4. Strike the remainder of line 77 and through primarily on line 78. Insert special events conducted on the premises of a museum. The second line amendment is on line 78 after interpretation. Insert that is owned and operated by the locality.
Okay, Mr. Chairman, those line amendments just narrow the bill a bit, and it's about ABC licenses. Right now, if you have a 501c3 museum, you can already obtain an annual permit for an ABC license. However, if you're owned by a municipality, you don't qualify for this annual permit. So what we're doing to narrow it further is we're saying that if you have special events conducted on the premises of the museum that's owned and operated by the locality, and not just a museum, but one that's used for historic interpretation by the locality, we would like to be able to obtain an annual permit. The museum in question, Gadsby's Tavern, where George Washington came, Gadsby's Tavern Museum, where Washington came for a number of events. I think it was Jefferson's inaugural ball. They do some historic reenactments. They do a lot of other events interpreting. They did one called History by the Glass. It's my understanding that they always serve food at these events. I've got the director of Historic Alexandria here to speak to the bill if there are questions, but there's some people supporting this. The people who sometimes oppose this stuff are on board with the amendment. So that's the bill, and I've got Ms. Gretchen Bulova, who's the director of the Office of Historic Alexandria.
Okay, great. Do any members have a question for Senator Evan while he's here up front? Is Travis, you still here? Okay. Any problem with ABC? Okay. Step on up, Ms. Bulova.
Hi, thank you. I appreciate the opportunity to say a few words about SB 588. And in the interest of time, right now, this is in the law that a 501c3 can already do that. So I'm asking that a local museum owned by a municipality can do this as well. It's simply streamlining the process. And right now, we apply for individual license every time we have an event. We have 7 museums. 3 of them do extensive public programming to expand our audience and increase people's awareness and enjoyment of history. And it's just simply a cost savings, a time savings for city staff and the ABC staff to have a year-long permit.
Great, thank you so much. Anyone else wish to speak to the bill? We're good. All right, thank you very much. We have no, we need to do that. Thank you, Senator Wagner. All right, it's been moved and seconded to adopt the amendments. All those in favor say aye. Any opposed? That's before us. All right, it's been moved and seconded to report the bill as amended on 588. Clerk, call the roll.
Ayes 15, no 0.
Okay, ayes 15, no 0. Senator Everett, you got another bill.
Yeah, Senate Bill 920 has to do with the adoption process in Virginia. It came to my attention from a couple who would be, I think, model parents in my district, that right now Virginia is deviating from national practice in that if you have a conviction of a drug offense like possession, a child placing agency can't approve you or you can't adopt till 10 years have gone by. In other states, it's 5 years. And there's a couple here, the Tarantinos, who want to speak to it. But right now, if you want to adopt in Virginia, you already go through a home study. You already have to be approved by a judge. And in 47 other states, this 5-year barrier exists just as we'd like it to change it to in Virginia. That's kind of where we are. And when I heard the story of the Tarantinos, I was surprised they couldn't adopt, and they can tell you more about why they'd be good parents if you'd like.
Okay, so does anybody have a question for Senator Ebanon in the first part of this? All right, if you'd like to have your witnesses come up to speak, that'd be certainly fine. Good morning.
Good morning. My name is Laura Tarantino. I'd like to excuse my voice. I woke up with a sore throat this morning. So again, thank you for letting me speak today. My name is Laura Tarantino, and almost a decade ago, I received a nonviolent drug-related felony for possession while I was in college. I don't have any excuse, but I have put this far behind me and live a very different life now. My husband and I want to adopt, but with current legislation, we have to wait 2.5 more years. I was told I have about 2 minutes to testify today and convince you that I am a great candidate to adopt or foster a child. I'm going to spend the first minute talking about myself and the last minute talking about my incredible son. For the last 2 years, I've been working at nonprofits. 2 years ago, I worked for RAIN and received my credentials as an advocate for victims. In 2017, I worked for FAM and advocated for criminal justice reform. I can provide references if you'd like. I also returned back to school. Last semester, I earned a 3.9 GPA while taking 6 classes, interning, and being a mom. I brought my transcript to prove it. This semester is my last semester of my senior year, and I was picked up as a teacher's assistant as well. This is my son playing hockey. He wakes me up at 5:30 a.m. every morning to go to private lessons before school. He loves math and chess. And this is a photo of us playing chess that the Washington Post had covered. That photo was taken when the Washington Post endorsed us as a family that should be allowed to adopt. Our son wants a brother. We want to bring a child into our home to raise and to love. We know we'd be a great parents to them today. Every extra year, month, or day you can give us with our families, kids, matter. Thank you for your consideration.
Thank you very much, ma'am. Yes, sir.
Hi, morning. Thanks for letting us talk today. As my wife said, we are at the 7.5-year mark, but current legislation in Virginia makes us wait 10 years. We've been fighting this for the last 2.5 years, and we're finally ready to adopt now. We've saved money, we've bought a house here in Virginia, we both have jobs, and we have an incredible 6-year-old, and all of our families here in Virginia. In 48 states, we'd be allowed to adopt. The federal law has a 5-year wait period. Most of the states align exactly to this, and we've been ready to adopt since the 5-year wait period. And like I said, in 48 states, we'd be allowed to adopt, and we know this because we've read all 50 states' legislation, and only in Alabama and Virginia are we not allowed to adopt. I know that the legislators who decided on the 10-year wait period are good people. But I think that this is an example of a law that has good intentions, but went overboard and doesn't consider people like Laura and I. For over a year, Laura has literally saved lives working for nonprofits and caring for victims of sexual assault. And I graduated the Air Force Academy and can literally be deployed to combat zones, but we can't adopt even after the 5-year wait period. I just want to say that please allow us to adopt. We're good people. Laura's had a stellar record for the last 7.5 years. She's done amazing. We have a great son also. She was adopted, and we both have always wanted to adopt. And like she said, these years, these months, these days, they matter to us. Thank you.
Thank you very much. Does anybody have a question for either the patron or these fine folks that came all the way this morning?
Mr. Chairman, I have a question.
Senator Sproul.
Is there anyone here who could tell me when I do agree that these people should have theirs, but somebody else may not? Is there someone here who could explain to me exactly what does the law says that will monitor anybody? Let me add, I'm trying to get out what I'm trying to say. They will monitor anybody when they have proof that they are ready. And I say yes to them. But what does the law say that will monitor anybody for 5, whatever time may be, to make sure that they are on a narrow and track? So when the next person come up, I want to make sure they are also qualified to adopt for 5 years. What does the law say about that?
Mr. Chairman.
Senator McDougal.
Mr. Chairman, I think what Senator Eben described as the concern that this couple has is a small subset of what the statute actually says. And I think this goes directly to Senator Sproul's question, and that is this references the barrier crime statute, which includes murder, rape, child molestation, acts of terrorism. There are a number of other violent felonies that are included in that list under 19-39202. And so the concern I have is that we're taking all these other violent felonies and including them in the same direction. So if we're talking about a simple possession felony, not a distribution, but a possession of felony, and it's 5 years, I think that might be a different discussion, but that's not what, I don't think that's what the language of the bill says.
Okay, and it was my intent only to deal with 18.2.
Let me interrupt you for a second because my attorney here is telling me that it's not that broad. So, David, do you want to hone it in?
Yeah, Mr. Chair, it would only apply to offenses that are set forth in Clause 4 of the definition of barrier crime in 19-2-39202, and that Clause 4 is possession of a controlled substance knowingly that was not prescribed by a physician. It wouldn't include any of the other offenses included under the definition of a barrier crime.
So, Mr. Chairman,
Hold on one second. So, David, it's a carve out specifically for that?
Yes, Mr. Chair. It would just be for possession of a controlled substance.
Okay, Senator Sproul.
Okay, so my second question, so if this carve out, so the others still would remain under the 10-year period?
Yeah, it's really up to the committee, but that's all, I was just getting after the drug issue, and if the committee wanted to broaden it, I'm afraid it might not pass. But I did want to just stress two things in closing at the appropriate time, Mr. Chair.
Go ahead, Senator Evans.
My question wasn't answered. I agree that these folks, under that stereo, yes, I agree with that. But getting back to the merger and what have you, that still will stay intact.
Yeah, and I think council said that, if that's correct.
Okay, thank you.
Yeah. The things I want to stress in closing was, if the Tarantinos want to move to West Virginia, North Carolina, Kentucky, or Maryland, or District of Columbia, I believe, they would be able to adopt after 5 years. It's just us and I think Alabama that they couldn't. And the welfare of the individual child is still my paramount concern. I want them to have a good, loving home. But it's important to remember that there's a home study conducted in each adoption case. And further, it's important to remember that a judge doesn't have to approve them. A judge would look at their record and decide, are these good potential adoptive parents? And they're successfully parenting another child. And, you know, I'd like to just see that child, them be able to give that same love to a child without a family now, a forever family.
Mr. Chairman. Mr. Chairman.
All right. Senator Hanger, then Senator Black.
Thank you, Mr. Chairman. I made a similar attempt a couple years ago, and what we got hung up on was the fact that the barrier crimes code sections was kind of in disarray. And so last year I spent several days in front of the House Courts of Justice Committee, and staff is very intimately familiar with this barrier code section because they rewrote the whole thing, worked on it a lot, and we got the bill successfully through to define. And the point that I would make, which I think just Senator Evans just made, is this says may. So in this instance, the placing entity and all those involved with the care of the child, the safety, well-being of the child will have a decision to make about whether or not it's a good couple like this or whether it's someone that doesn't deserve to have the children. So I do support the bill.
Thanks, Senator Hager. Senator Black.
Mr. Chairman, I just mentioned that, probably 8-10 years ago, I passed a bill for similar purposes. Now, it had a 10-year period, but it dealt with, it was an assault. It was a simple assault. And and it was very narrowly carved, which I believe this is also. And so I do support the bill also.
Thank you. Senator Wagner.
Mr. Chairman.
Senator Favola, go ahead.
I'm ready for a motion. I move that we report the bill. Second.
Good. All right, I have a motion to adopt the bill as a, did we amend this bill, David? Was there an amendment? A motion to report the bill. It's been properly seconded. Committee will vote.
Ayes 15, no 0.
Ayes 15, nays 0. Thank you so much, folks, for coming out, and hopefully let's get Senator Wagner.
From Mr. Tarantino, who won the Navy Air Force game this year?
I think it was Navy, sir.
Senator Evans, you have one bill left?
Yes, sir. The last bill is a bill that's similar to what's been approved, but 606, Senate Bill 606. In the past, I guess it's this committee and the appropriate committee on the other side had approved a bill to create an Office of Immigrant Assistance in Virginia. And in fact, both parties had funded it in different years. This year it's funded in the budget. Now, what this office would do was advise and assist people with legal status in this country through the citizenship application process, and also help them and appropriate localities and immigrant service agencies know what they can do to help people secure employment, about state programs, that sort of thing. But the piece that I put in this year that I added, particularly that I think is super important, is it would provide information to localities and immigrant service organizations regarding health epidemics, unlawful predatory schemes such as human trafficking, gang recruitment, fraudulent financial and other schemes to which communities of such persons may be especially vulnerable. And we are one of the top 10 states with immigrant populations. We lead the country in the share of foreign-born residents with a bachelor's degree or higher. We have a much higher rate, I believe, of immigrants we know are more likely to start their own small businesses. So they're important to the economy, and if they're more rooted in the country and the state of Virginia, I think that's a benefit to the Commonwealth. We have about 29,242 green card holders in this Commonwealth, as well as refugees. Asylum applications, we have a lot too, but they're not eligible unless they're approved. So it's quite a process to go through the citizenship process. I just want to help people who are going through it legally. It's more than a test on the first presidents or any of the presidents. It's a lot of, if you're from another country, or even for me, if I'm from this country, which I am, it's a lot to go through. And we just want to help these people through the process, help them become even better taxpayers.
Thank you, Senator Ehrman. Anybody have a question for Senator Ehrman?
Mr. Chairman.
Senator McDougal and Cosgrove.
Senator Eben, any part of that immigration process involve a state application or state government?
Well, the state government particularly, as you might know, the state doesn't approve the immigration status, but the part that would involve the state particularly is to prevent these scams, frauds, try and prevent people from joining gangs, that sort of thing. You voted a few years ago to outlaw notario fraud that was preying upon people in the Latino community, in banking, from people representing, I shouldn't say banking, people who are notaries posing as lawyers, that sort of thing. That's part of what it is.
Mr. Chairman.
Senator McDougal.
But this would be a state agency that is advising people on how to fill out applications that are exclusively federal applications.
Well, yeah, it's a little bit more than that, but I think it's an employee and a half, yes.
Senator Chafin, do you have a question?
Or two employees.
Senator Evan, have you, I noticed that this has a pretty good fiscal impact. Have you filed a budget amendment to accompany it?
It's in the budget that is before the Finance Committee. So I have my impact statement here. I think we may have filed it, but it says budget amendment necessary, no. So I may have put in a placeholder, but it's in the budget that will be considered by the Finance Committee for them to approve or not to approve.
Thank you.
It's in the governor's introduced budget, but it'll still need to go to finance. Senator Cosgrove, did you have?
Yes, Mr. Chairman. I think Senator McDougal asked the question, but I want to just clarify it. We're spending, at least in 2019, in the budget, almost $500,000 to do something that's really a federal function. Is that pretty much an accurate assessment of what's going on here?
A large piece of it is a federal function is helping Virginians, just as we help Virginians fill out for programs like, partly federal programs like TANF or food stamps or those types of things. This one, though, is not limited to people who need assistance from the Commonwealth. It's geared at getting people even more self-sufficient.
Mr. Chairman.
Senator Cosgrove.
I guess, the difference between TANF and food stamps, as Senator Eastef just kind of whispered to me, those are state-administered programs, but this really is more a federally administrated program. Is that accurate?
Well, yeah, whether or not you become a citizen is up to the federal government. You're absolutely right.
All right, thank you very much.
Okay. Anybody else have a question for Senator Evan on this bill? All right. The committee operates by motion. All right, so I have a motion to report and re-refer to finance. It's been seconded.
Substitute motion.
Okay, substitute motion, Senator Cosgrove.
Pass by indefinitely.
And it's been, the secondary motion is to pass by indefinitely. It's been properly seconded. All those in favor to PBI, Clerk Clawlow.
Ayes 7, nays 8.
Ayes 7, nays 8.
Mr.
So
Chairman.
we go back to the primary motion.
Mr. Chairman, voting on the prevailing side of the last vote, I'd like to have it reconsidered or stricken.
Okay, so we'll reconsider the last vote. All those in favor of reconsider say aye. Any opposed? Okay, so the motion is to PBI the bill.
Ayes 8, no 7.
Ayes 8, no 7. Okay, that bill is finished. I think that's
Okay,
all you
thank
have,
you,
right,
Mr.
Senator
Chair.
Evans? You
Thank
bet.
you.
Senator Servo, you wanna, let's get your bill rolling out of here?
Thank you, Mr. Chairman. I think it's
769.
right. And this is a bill so the Virginia Beer Museum can sell beer. And we need to make a line amendment.
Okay.
Basically, on lines 69 through 72 is sort of where the key language is. And we just need to strike on line 71, manufactured by a limited brewery license. So it'll just read, may sell and serve beer for on-site premises consumption.
Okay, and this is another museum bill, right?
Yes.
Okay, all right. Does anybody have any questions for Senator Servo? All right, the amendment's been moved and seconded by Senator Cosgrove. That line amendment, all those in favor say aye.
Aye.
All right. Well, it looks like it's on a fast train, so I have a motion to report the bill. It's been properly seconded. Senator Cosgrove?
Mr. Chairman, ask the patron, do you represent Front Royal?
No, but there's a member of the board who's standing behind me who's a fellow criminal defense lawyer who called me up because he knew I was a legislator, knew something about this, and so that's why I got involved in this.
Okay, thank you.
Got it. All right. So the motion to report is in front of us, has been properly seconded.
Mr. Chairman,
Senator Easton.
just a quick question. Since this is specific to Front Row, will this require 80%?
Senator Servo, did you hear the question?
I heard the question. I didn't draft it that, I mean, I didn't intend to draft it that way, but I don't know. The big question for the Lieutenant Governor eventually, I guess, but.
Mr. Chairman?
I hope it doesn't sound like, I didn't hope it's not an issue in terms of the vote.
Mr. Chairman?
Senator McDougal.
Procedurally, 80% is required for an emergency clause.
Right.
It's a 2/3 requirement for a specific jurisdiction. And I don't know if this is going to, it's going to be close, but it's not in the committee, it would be off the floor. So that vote would be, if it is specific jurisdiction, it's 27.
Okay.
Thank you, Mr. Chairman.
You bet. All right, the motion's before us, been properly seconded. All those in favor of voting for this bill, vote aye.
Thank you.
You bet.
Ayes 15, no 0.
Ayes 15, no 0. Senator Mason, you have your bill?
Mr. Chairman, members of the committee, this is Senate Bill 555. We've heard it once before, and I just wanted to visit a couple of things before we discuss it. First, when I went home, the gentleman that was intended for it sent me a note and his card that he currently works at the Hampton Newport News Criminal Justice Agency. He's also He sent me a resume like I didn't even know him, but he's been appointed by a judge to be on a mental health docket review board. In 2006, we set up the Virginia Commission on Mental Health Law Reform. The quote from that report said, failure on the part of the providers to fully understand the importance of peer support, limited funding to expand services, a decrease in support for the training of peers, and barrier crime limitations on employment and state and federal laws have all contributed to the very slow growth of peer support employment in the Commonwealth. Mr. Chairman, members of the committee, you know we're in the midst of an opioid crisis. I want to make a couple of points here. This adds, Senator Hanger spoke to the complexity of barrier crimes. This is one, burglary only. And you still must be screened. This just makes you eligible to be screened. Last year, 35 people would have qualified ostensibly to be screened. Doesn't mean all of them were. If your CSB decides you don't want to hire anybody, so they apply, you like him, background check comes back, and they need screening. Your CSP can say, you know what, we don't hire anybody that needs to be screened. But if they choose to do so, you will find on lines 91 to 98, to be eligible, shall not be under probation or parole supervision, no pending charges in any locality, paid all fines, restitution, and court costs for any prior convictions, free of parole or probation for at least 5 years on all convictions. The CSB does not provide this screening. DBHDS does. In fact, they find it to be a conflict of interest if one of their 3 screeners for the state works for the CSB that is having someone screened, so they'll bring someone else in. No cost to the CSB, no requirement to the CSB, and with what we're in the midst of today, Mr. Chairman, members of the committee, we need to push this legislation forward.
Thanks, Senator Mason. Senator Black, you're in the queue. Did you have a question?
If I could just ask you, I'm not sure how familiar you are with burglary, but it's it's particularly serious. It is the entry into a house at night, and the reason is that it presents a danger. I was involved in a physical altercation with a burglar who entered my house, and we fought. He slammed me on the head with a steel box, and to his great misfortune, he turned around at the wrong time, and I stabbed him with a snake hook about 4 inches through his shoulder. Burglary is not a lightweight offense. This is a big deal.
Mr. Chair.
So I think it's just when we're talking about this sort of thing, we need to understand burglary is not just a minor offense.
Mr. Chairman, Senator Black, I've read the definition. You're exactly right. That person would not pass the screen. Or if your CSB, if that came back, your CSB can say, no way, we're not even screening. And we don't hire people that even need to be screened. It is entirely dependent on what the local CSB wants to do. In your case, they would no way they would screen. And you're right, I do not mean to underestimate the severity of the crime. But sir, we've got some folks here to testify who have that in their past and are providing great services to people in need today.
Okay. Senator DeStaff, you're next, and then, okay, Senator Servo, you have a question on this one?
I think I'll wait for DeStaff, and I'll wait till the end.
Okay. Senator Mason, you have some folks
Yes,
that
sir,
want to
I do.
testify?
Thank you, Mr. Chairman.
Have to step up pretty quickly, sir.
Yes, sir. Good morning. My name is Marlon Baycoat. I'm a registered peer recovery specialist. I'm also a Virginia board certified peer recovery specialist in the state. I have a burglary charge. My burglary charge was 28 years ago, 1990, and it was a empty house, a empty residence. I went in that empty house with a friend 28 years ago. And since that time, I've changed my life. I've gotten through a substance abuse program. I'm a graduate student at Liberty University. I've also taken naloxone training. Speaking to the opioid epidemic, I saved a man's life last year and was on the news. A man had died. He had opioid and fentanyl. He had heroin and fentanyl, and he had crashed into the back of another vehicle. Still with the needle in his leg. Because I was able to have the Revive training at the CSB, I was able to move into action and save that man's life. My 28-year-old burglary crime, I don't think light of it. I don't think that crime should be ignored, but I also don't think that the experience that someone like me has shouldn't be ignored either to help people recover from substance use disorder and mental health issues. That's why Virginia created, well, actually, the peer recovery specialist came into play for 2004 from the Clay Hunt Act because he was over in cross seas in Afghanistan, came back over, committed suicide. Congress put out billions of dollars for peer recovery specialists, yet Virginia can't stay competent in the area of mental health because a lot of the people are being denied because of barrier crimes. And the work, not just saving a man's life last year, but I noticed that because I am clinical also, but I know that lived experience can't be matched. And when I go into neighborhoods in Newport News and Hampton that my clinical colleagues don't get along with the parents or they can't relate, I believe that's why the 13-year-old child that was with me last year leaned over in the car and spoke of abuse. That child's uncle was removed from the home, and he calls me, now he's in school and he's doing a lot better. But the other counselors, everybody else, it's hard to relate. I'm out there, I'm boots on the ground. I don't mind going where other counselors won't go. And I think that's where the mental health, the bulk of mental health issues and substance abuse is needed. So this barrier crime really needs to get passed.
Thank you, sir. You got about 30 seconds, so if you could just tell us who you are and what you're in favor of the bill.
Sure, Bonnie Neighbor with Vocal the State Mental Health Consumer Network. Peer Services, Peer Recovery Specialists are an evidence-based program. It's people who have walked the same walk as somebody else that doesn't work to sit down and say, I haven't been arrested. We support this bill.
Thank you. Yes, sir.
Good morning. My name is Chuck Adcock. I'm the owner and program director of Family Counseling Centers. We operate 3 treatment centers here in Virginia, and we support the passage of this bill so that we can hire folks in this situation.
Thank you, sir. Yes, ma'am.
I'm also a convicted felon for a drug offense, and based on the current barrier crimes in Virginia, I would not have been able to work in this field.
Thank you.
Good morning, Mr. Chairman, members of the committee. My name is Jennifer Faison. I'm the Executive Director of the Virginia Association of Community Services Boards, and we support this very narrowly drawn, very narrowly crafted and important bill that would allow some flexibility for hiring individuals who have lived experience into our system. Thank you.
Thank you. All right. Senator Sturteville, you still have a question?
I don't have speaking to the,
Okay.
I would move to report and speak to the motion, I guess is the proper thing to do.
Okay. Let me get through the other questions because my grid is filling up now.
Got it.
Senator Eastep, did you have a question?
Mr. Chair, Senator Mason, would a pardon by the governor absolve that barrier crime issue on this one?
No, sir. The gentleman in question, Mr. Chairman,
Go ahead.
Senator Steph, the gentleman in question has a pardon from the governor.
Okay. Mr. Chairman, if I may.
Senator Eastep.
My concern with this isn't just the CSBs, but Department of Health and Behavioral Services. And here's what happened in Virginia Beach. In Virginia Beach last year, we had a young lady working for DHBS, and she was responsible for the checkbook and the financial, wherewithal for our most vulnerable population. Now, she wrote checks out of that checkbook to herself to the tune of $50,000 just from one individual. There were a few more that she wrote as well from others that she was overseeing. But my concern is, we have this for Department of Health and Behavioral Services and the CSBs, we have this there really for a reason of barrier crimes. And if you're breaking into somebody's house, and think about their house, that's the American dream. That's where people who are veterans fought in wars overseas to protect. So, that's your basic underlying right. And if you're going to break into somebody's house, their safe haven, then I've got a concern with that. And I'm not sure if I'm willing to say, hey, it's okay, and you can work for a Department of Health and Behavioral Services, or you can work for a CSB. It's just there's an underlying moral fabric here that I'm having a hard time with, and I just can't support this bill.
Mr. Chairman, Senator DeSteff's situation in Virginia Beach is not impacted at all by this law. In fact, if that person had been properly screened, they may or may not have ever gotten the job, sir. So I would argue that maybe the law as it exists on the books now was not followed in that case. I don't know. I understand the definition of burglary, and that's why you have to be screened. That's why and again, if your CSB says, no, we're not doing this, we're not going to hire anybody, that's it. It's over. They don't have to screen them. They don't have to ever bring them back again, sir. Right. The CSBs are asking for this, the statewide CSBs, the Virginia Beach CSBs. So I understand our pause, and I understand I took a lot of law and order votes in the House Courts of Justice Committee, sir, and I spent a lot of time with barrier crime. So I don't go embark upon this lightly. This is important. I'm sorry, sir.
Okay. Senator DeSteff, let me cut you. No, hold on. Senator Wagner.
And, Mr. Chairman, my brother-in-law is a recovering addict.
Yes, sir.
And I went to his 10-year birthday party, not because he turned 10 years, but it was a 10-year celebration. And he has somewhat of a checkered background, as you might imagine,
Yes.
prior to recovery. And my experience through him tells me that it takes a recovering addict to help another addict. And he very much enlightened me to the program. He very much told me that. And quite frankly, it's probably the only people, after various health clinics get these people through these initial phases of withdrawals, the only person that another addict can relate to is a recovering addict.
Yes.
And those are the people that can actually provide the long-term support. And in a strange way, as my brother-in-law explained it to me, it helps him stay and hit conditions of 10 years like that. If we're going to have positions like this, and we should, given the extent of the problems that we have in the Commonwealth of Virginia, I think it's important that we understand that we know there's a program out there that works. It's been out there for a long time, decades, and it works. And I think it's important that we do that, recognizing that we may ask that some people become professional at what it is they do to help those people. During the time when they were not in recovery, they were obviously using and abusing and supporting their habits and doing those types of things that are going to create a record of some time or another. And I think that as we continue down this road, we need to be very, very look at these kinds of things and these barrier crimes we've established for people that have proven themselves to be on that long road to recovery, that can actually provide the exact assistance we need to so many other people that haven't started down that path yet. And I think it's important that we recognize that. And I would hope, and I'm intend to support this bill, but I would hope that we would look at that in the context of programs that we know have been out there for a long time that work, most of which require no government funding. In fact, they look away from having any government funding provided to them. However, those that fit the category of professionals that can come in and go into addicts that feel like their life is hopeless and offer them a path out. Because as far as I've seen, and my brother-in-law has made it very clear to me, there's only 3 paths once an addict has. It's jail, death, or recovery. There's only 3 ways you can go. And obviously, I think we would like to encourage, and I know we're going to hear from Senator Stolley and Siobhan a little bit about the massive problems going on in Virginia Beach Jail. So I intend to support the bill, but I think it's important, particularly for this committee, to understand out there and take a look at some of these programs and get involved. Take a few minutes to go in and take a look at some of these programs and begin to understand what works out there and what doesn't work. And I'm not saying all these programs work. And those that don't, we need to weed out, but we need to be very sensitive to these kind of problems. And you know, if it need be, my brother-in-law would be delighted to come in here and tell you as only he can. And it may not be the most artful thing, and you may learn a few new words, but he's very, very clear about what it does, and certainly been an eye-opener to me about the things that work and don't work. So I intend to support this bill. Thank you.
Thank you,
Thanks, Senator Wagner. Senator Cosgrove.
Mr. Chairman, we heard a lot on this. I have a little bit of concern, but I think that Senator Wagner's points are absolutely on point. So I would make a motion to report the bill.
All right, so I have a motion to report the bill. It's been properly seconded. Let's vote. Frank, you want to vote?
Frank.
Thank you, Mr. Chairman.
Ayes 11,
members of the
noes
committee.
4.
Ayes 11, noes 4.
Thank you, sir.
Thank you for your testimony too, Frank. Senator McDougal, you have 884. We can probably get out of here pretty quickly.
Mr. Chairman, 884 is pretty straightforward. It raises the licensing fees for 4 different areas of ABC, retail license application fee, banquet special event and mixed beverage special event license application fee, wine shipper's license, and beer shipper's license. Mr. Chairman, certainly in the Senate Finance Public Safety Subcommittee, we've heard a lot of conversation from ABC about the number of enforcement individuals that they have currently on staff and the cost of that enforcement. And as we've increased the number of licenses, their inability to get to every particular license. And Mr. Chairman, with this, I know this is one question we always ask, ABC will still not be recouping the full cost of its the license process. So, Mr. Chairman, originally we had a fiscal impact estimate that was about 1.8 million from these increased license fees. We found out that it's less than, after we did some more in-depth analysis, less than half of that. So it's going to be less than 900,000 from these increased fees. So we still are not approaching the actual cost of administering these fees going forward.
Got it. Anybody have any questions for Senator McDougal? Travis, did he sum it up pretty good? Okay. It looks like you have someone behind you who wish to speak.
Mr. Chairman, I'm sure that not everybody wants to pay for the actual cost of enforcement, but
And with that, yes, ma'am.
Mr. Chairman, Terry Burton, Eastern Council with Wine Institute. I'm not opposing the increased license fees for direct wine shippers. I wanted to give you a little background, however. I lobbied this body in 2003 when we passed the direct shippers bill, and that legislation has proved to be a model for the rest of the country, believe it or not. Virginia's one of the earliest of now 46 states that allow wineries to direct ship to consumers. It's one of only 14 states that allow retailers to direct ship to consumers. But it has proved to be a model program. You've got about 1,200 out-of-state direct wine shipper licensees, and most of them are members of Wine Institute. They try hard to do the right thing in all 46 of these states. And we're encouraging you to direct any increased revenue from these license fees to enforcement against those that are choosing to not comply with the law and not file their application for direct wine shippers and do the right thing. So please direct any new resources from these license fees to enforcement programs that might make the program stronger for everybody. And I understand ABC is going to be increasing their fees on all the other, or looking at increasing their fees on all the other license types in the future. So if you increase them on this one this year, please don't increase them when you do an across-the-board fee increase next year. Thanks for your consideration.
Thank you, Mr. Boykin.
Mr. Chairman, members of the committee, Phil Boykin with the Virginia Beer Wholesalers Association. We wholeheartedly support this, and thanks Senator McDougal for bringing it forward. And we've been working with ABC for the past year, and we look forward to continuing to work with ABC as they continue to look at fees. ABC needs more enforcement. They need more agents on the street, and any resources you can give them is much appreciated, and hope these resources stay within ABC. Thank you, sir.
Thank you. Mr. Lisk?
I'll be very brief, Mr. Chairman. Tom Lisk, representing the Virginia Restaurant, Lodging, and Travel Association. We support this bill. We appreciate ABC, rather than doing an across-the-board increase, is looking at targeted areas where they can increase revenue to support enforcement activities. We think there's an absolute need to increase enforcement activities and resources, so we support the measure.
Thank you. Senator Cosgrove? Okay, we're good. You'd like to speak, Travis?
Just to thank the industry for their support. As Ms. Burns said, this is the first step. We have been reviewing our fees, and we are not recovering the cost of enforcing with the fees we're currently administering. So you will probably see us back here next year with another study to show where else we need to look. But we appreciate your support. Thank you.
Second.
Hold on. See, you shouldn't have spoke. Now you just started a fever. Senator Cosgrove.
Yeah, Mr. Chairman, a couple of things. Number one, Mr. Hill, I'm looking at the bill, and Senator McDougal's bill basically triples the fees that we're charging now. I've been here a long time, and I haven't seen a whole lot of tripling of fees in bills that actually passed. The other thing is, Mr. Chairman, that isn't your profit margin supposed to cover your enforcement as well?
I think that the way we've looked at it with the enforcement fees is we'd like to be self-sufficient on the enforcement side in order to fund the activities. That was something that our study showed, was that our fees fall short of enforcing that. And that's what we've tried to do, is make our fees sufficient to fund our enforcement activities.
Mr. Chairman, one other question.
Go ahead, Senator Cosgrove.
Did you say you're coming back next year for more?
We're going to work with the industry and determine what the needs might be and how we can run enforcement. So just wanted to let you all know.
That would be a yes, then.
Yes, sir.
Yeah. Okay, thanks.
if we can generate the same type of support we have today.
Chairman.
Mr. Chairman.
So there's a motion to report the bill.
Mr. Chairman, before you get there, I think there's a technical, we thought that it was covered, but staff
ahead,
caught
Dan.
it, was we went through amendment, which I'm going to move after he reads it.
Second.
Mr. Chair, essentially the bill amends the beer shipper and the wine shipper license, but inadvertently did not amend the wine and beer shipper license. So the amendment takes care of that on line 158 after license, strike $95, insert $230.
Okay, it's been moved and seconded. All those in favor of the amendment say aye. Any opposed? All right.
Mr. Chairman, I'm going to move that we report the amended bill, but just want to assure Senator Cosgrove, one of the things that we're strongly encouraging ABC to look at is how they've made up their enforcement team, and maybe we could do things in a more cost-effective manner in providing additional enforcement by maybe looking at non-sworn individuals that could do a lot of this enforcement. We're seeing what has happened over time, particularly with as Ms. Burns described, the out-of-state people shipping in. That is labor-intensive research going through that process of looking at each shipping manifest from entities like FedEx and UPS and DHL, and then doing the cross-reference back to what's coming in. It can be done. There is a process to do it, but it is very time and labor intensive. One of the things that we're hoping going forward is that ABC will see the wisdom of maybe not needing a sworn law enforcement individual to be doing a lot of that type of work as we go forward that would increase our enforcement side, make sure we're not distributing alcohol to people that should not possess it, and also keep the cost less going forward. But that's a different committee that we're looking at.
We got it.
Okay.
Chairman.
I think it needs to report and re-refer to finance.
Okay. All right, there's a motion to report and refer to finance. It's been made and properly seconded. Senator Youssef, do you have a comment?
I do, and I'm going to make it very, very quick. And Mr. Chairman, I believe it was last year, the year before, the governor came out and increased the cost of alcohol by, I think, going up to a 6 or a 7, whatever it was in the last number. And part of that justification, he explained, was for enforcement. So we get more profit for enforcement that we're supposed to use for enforcement. Now we're going to triple fees, and then we're going to come back next year to look at it and raise them again. So I've got a lot of concern with this, and I can't support something that's going to continually increase fees and increase profits. And we use the term, we're going to use it for enforcement, and there's a point where it's a self-licking ice cream cone, and I think we're going that direction. So with that, I'm not going to support this one.
Okay, so we have a motion to report the bill and re-refer to finance. It's been properly seconded. Members will vote.
Ayes 13, noes 2.
13-2. So,
Thank you,
all
Mr.
right,
Chairman.
thank you, Senator McDougall. Senator Donovan.
Thank you, Mr. Chairman and members of the committee. I'd like to talk to you today about Senate Bill 878.
Committee will go to 878. And Senator Donovan, let me just tell you, we got about a half hour left and about 7 bills. So I'm going to keep you kind of tightly reined in. So if you can be concise to the committee, that'd be great.
I'll do the best I can. The reason behind this bill is that we are all very aware of the statistics of at least 30% of the people who are currently imprisoned in our jails are there because of mental health disorders without adequate treatment in the community. We have had deaths in our jails most recently. There's been a lot of investigation about the medical services that have been in our jails. And one of the major challenges to actually meeting the needs of this population is that we abandon them when they leave the jails. They may get stabilized in the jails with inventive programs that our sheriffs are providing, but they are being abandoned with only 2 days of medication, and the CSBs may or may not connect with them. So we have 2 silos of government that send money down the silos, and the dollar never follows the patient. This is a way that we can connect the CSBs to the jails to create a pipeline of care so that those patients not only are cared for in the most appropriate way while they're in the jail for mental health disorders and substance abuse, but also when they leave, they have the supports in place in the community and they don't have to go into the jeopardy of whether or not they'll be accepted by the local community services board. So I think that's basically in the nutshell. I want to address a couple of issues There's been some pushback on cost here. I want to be clear. The cost is assessed to the jails. The jails are already paying for these services in the jails. They're just paying to a different silo than the CSBs. By connecting the CSBs in on this care, we are going to better serve these members of Virginia. We're going to do a better job of watching our dollars too. I do have some people to speak to the bill, Mr. Chairman.
Thank you, Senator Donovan. Folks that you want to step up real quick?
Morning, Mr. Chairman, members of the committee. I'm Rhonda Thisson with NAMI Virginia. I'm here to support the provision of the bill that would require the jails to develop standards for mental health treatment. I mean, as Senator Donovan said, you know, we have a large number of people in our jails. I think over the last 10 years, according to the Compensation Board, there's been about a 30 to 35% increase in the number of people with mental illness that are in our jails. We have no position on the aspects of the bill that would require the local jails to contract with CSBs to provide these services, but we do believe that there should be some standards in jails for how people are assessed and how they're treated. Thank you.
Thank you, ma'am.
Sorry, Mr. Chairman.
Mr. Chairman, I'm Ken Stoney, the Sheriff of Virginia Beach, and I asked that Siobhan carry this legislation. And I think that what you have to realize is, who do you want providing your mental health? And you want a sheriff providing your mental health, or you want 123 different sheriffs providing your mental health to the most needy mentally ill, or you want the professionals providing that help? And I think you want the professionals providing that help. The second step is we don't have a seamless transition. We've entered into some agreements with the community service boards to try and have a seamless transition for the seriously mentally ill, but we don't have that yet. And this would, it makes no sense to me that I spend $1.5 million a year buying outside mental health care when we have somebody that's responsible for the mental health in the community and they're not providing the service. And I went to them about 3 years ago and suggested that I'd pay them $1.5 million, and they declined for reasons they didn't think they had the resources to do that. Let me just tell you that we do a lot of things in Virginia Beach. The most important thing we try to do is identify a mental health problem when they come into the jail. And if we identify, we try and get them on their meds right away. We have a suicide prevention room. We have detox. We have 4. We've increased our medical staff, our social service staff to 4. We have a general district court program, a circuit court program, and we have substance abuse. We have a transition to the outside program where we, have the inmates go through practicals on what they need to do on the outside, but what we don't have is a seamless transition. And so without the seamless transition, this is what you're going to get. I had a study done of our 2,000 and our seriously mentally ill. We have a pod that we use to keep our mentally ill in, and we house them separately so they get the treatment that they need. But we did a study of the 2,000 mentally ill, seriously mentally ill patients or inmates in our jail. Of that, there were 50 that went through the pod. Of that 50, 47 reoffended within 3 years. 47. It's a 95% recidivism rate. And I've been in your seat before, and I am unaware of any recidivism rate in the nation that is close to that 95% recidivism rate. So we have a serious problem, and we're not addressing it. And I think that we need to have the social service, we need to have the community service boards and the jail providing the services. So I'll be happy to respond to any questions that you all have.
1 second, Senator Wagner. Senator Favoli, you have a quick question for Sheriff Stolley?
I'm very supportive of this bill. My question is, are the CSBs obligated to provide the service? Could they contract it out to a third-party provider? Are you looking for case management from CSB or the actual delivery of service, or is there some latitude in here?
So this directs the Board of Corrections to adopt the standards. So those kind of variables could vary, even from locality to locality. But there would be standards that were adopted by the Board of Corrections so that we could figure out a way to do this that was feasible.
So Mr. Chairman, just a quick follow-up question.
Go ahead.
So the delivery of care would be flexible. It would be streamlined based on what resources were available and how to best bring them together.
Transitioning from in-house in the jails to our community service boards, right?
Mr. Chairman, if I could, I think the biggest problem with this is the fact that if I were in the community service boards, and I don't think they're here to oppose the bill, but if I were the community service boards, I'd be concerned not about the treatment in the jail, because the bill is very clear that the treatment in the jail gets provided. I think there's an amendment that you need on the bill. It's online. I think it's 120 or line 30, line 124, after shall pay, you need pursuant to section 53.1-126, which is the bill that requires the cities to pay the cost of this, and the sheriff pays, the cities pay the medical bills for the sheriff. So this is not going to cost the counties any more money. They're already paying this stuff. And so what we have to do then is figure out why the community service boards are opposed to this. And I think the reason they're opposed to this is if they're being paid the money to provide the service while they're in jail, then it's the continuation of treatment that they have to provide once they get out of jail that they're concerned about not having the resources to provide. If they're concerned about that, then they're admitting our system has failed because they're not getting the transitional services and not having a seamless transition that you need to have. And so they're admitting that they can't provide those services. And that you know, with a recidivism rate of 95%, that's devastating. That's a death sentence.
And they're paying
Right.
anyway.
Okay, all right, hold on one second. David, so we have a line amendment? All right. Let's hear the line amendment, and then we'll go ahead and do it.
Mr. Chair, the line amendment would be on line 124 after pay, insert comma pursuant to section 53.1-126, comma.
Okay, so the motion is and seconded for the line amendment. All those in favor say aye. Aye. Any opposed? Okay, that's before. Senator Wagner?
And Mr. Chairman, I was going to defer, but if you haven't had the opportunity, I think it would be great for you, Mr. Chairman, and I'm going to ask Senator Staley a question in a minute, that this entire committee take a tour and see what's really going on in our jail right now. And I will commend Senator Staley, Sheriff Staley, for the good work he's done there. But if you haven't seen it in person, you have no idea what's going on. And I took the tour. So my question to Senator Staley is, would you be happy to host this committee and perhaps some other members on a tour to show what's going on today?
I'd love to do that. The more knowledge you have, the better decisions you make. And I think that it would be very informative.
Mr. Chairman. Okay, I think we have a couple of folks that might want to speak against the bill. Mr. Jones, I'm assuming the Sheriff's Association is in favor.
We're in favor of the bill,
Okay.
Mr. Chairman. And I
Thank you.
don't know what I can add to it, but we did send the bill out for review by our members, overwhelming in favor of it. It provides transitional services, and importantly, it establishes that the Board of Corrections will set standards on mental health. We need that.
Gotcha. Senator Hanger?
Thank you, Mr. Chairman. First, I want to compliment Sheriff Staley, our friend who's worked with us a lot. He is a creative thinker, and he's had a passion for resolving this problem for some time now. And it really dovetails with some of the work we're doing with the Mental Health Commission. And I can understand the CSBs. They're concerned about connecting the dots with paying for this. And I think clearly, not to derail it, but it's going to have to go through finance. At an appropriate time, I would certainly move that we support. It's a great concept. It really dovetails with what we need to do. And I think, you know, we have to address the concerns of the CSBs, but it will have to go to finance.
I got you.
Mr. Chairman, this is the right time to make approval.
Not yet. Senator Serval?
I have a question for Sheriff Staley real quick. I mean, I'm sensitive to this. I had a client who hung himself and pretty much killed himself this year in the Fairfax County Jail, and so I'm very aware of the issues that you all are dealing with, especially with the opiate crisis and everything else. My question is, you said you spend, I think, about $1 million a year or $1.5 million, whatever it was. So if we do this, what happens to your $1.5 million?
It would be redirected to community service boards. Whoever provides the mental health treatment would get that $1.5 million. And so, you know, there'd have to be a billing system, but I'm required by state law to provide pay all the medical expenses that occur in jail, and I consider mental health expenses medical expenses, and so does the city of Virginia Beach. And so I would submit those bills to the city of Virginia Beach, and the code requires that they pay them. And so I don't think that they have to worry about the services in the jail. I think they have to worry about the services after the release from jail. Yeah.
All right.
Gotcha. All right. Senator Sproul, did you have?
Move approval.
Okay.
Refer to finance.
So there's a motion to approve and re-refer to finance and been seconded. All those in favor vote aye.
Ayes 15, no 0.
Thank you, Mr. Chairman.
All right, it's 15-0. Those people that didn't get the opportunity to speak against it, you'll get an opportunity to speak in finance against the bill. My apologies.
Senator Reeves, you have a series of bills to be heard.
I do, Mr. Chairman. If we could take up Senate Bill 467, it has to do with cigar shops, and I think there's an amendment to that bill and a negotiated settlement, I think.
Clerk will report the amendment.
Mr. Chair, there are two line amendments. The first is on line 443 after 17, comma, strike the or, insert the or back in. The second is on line 444 after 18, strike comma or 19. It's just a technical fix.
Second.
Been moved and seconded that those amendments be agreed to. All those in favor say aye.
Aye.
Any opposed? Okay, the bill's before us.
Thank you, Mr. Chairman. This isn't the first time you've heard this bill, but I think we finally have peace in the valley on it. What this does is create an ABC statute for a limited mixed beverage license for retail cigar shops. We originally talked about allowing them to give away alcohol for free and some of those other things. What this now does is allow them that limited mixed beverage license so these cigar shops can continue to do what they're doing. It does define cigar shops that cater to patrons who smoke or purchase cigars annually receive 60% of its gross revenue from the sale of premium tobacco products to include a minimum of $200,000 and 40% or more of its gross revenues from the sale of cigars, and has at least one display humidor that stocks no less than 5,000 cigars and is open to the public on a regular basis. So what we're talking about, Mr. Chairman, is literally these cigar shops, not some retailer that just has a few cigars, but those that are actually in the business of high-end cigars and that sort of thing. And that's the bill. I do have Mr. Oakey here to speak to the bill as well. And
Just 2 seconds. Are there questions for the patron?
Just one, Mr. Chairman.
Senator Cosgrove.
And I'm sorry I missed the amendment. You and I talked earlier, Senator Reeves. You said that basically the sales had to be from tobacco, but do we also include tobacco-related accessories and that type of thing?
It's already in the actual bill itself and the original language. I know we talked about trying to get some of those ancillary items in there, but if you want to talk to that, that'd be great.
Mr. Chairman, yes, if you look in the bill on page 58, 59, and 60, it says at least 60% of gross revenues from the sale of premium tobacco products to include at least $200,000 and 40% or more of the gross revenue would be from the sale of tobacco itself, of premium cigars. Premium cigars and premium tobacco products are defined in the entire paragraph, which ends on line 67.
Did that answer your question, Senator Cosgrove? Okay. Any other questions for the patron? Anyone? Mr. Lisk, I see you up there. You have a comment?
Yes, Mr. Chairman. Tom Lisk, representing the Virginia Restaurant, Lodging, and Travel Association. If I understand the amendment, it simply takes out the provision that would allow the cigar shop to sell, but still allows cigar shops any day of the week to give away 2 drinks, whether it be mixed beverages, wine, or beer, to any customer coming in, whether they're buying cigar products or not. If that's the case, then we are still opposed to this measure because we believe it's still creating the first standalone bar in Virginia where there's no kitchen, no food, no nothing, just people can come in and drink alcohol. Unlike with restaurants where you know from past years there are absolute food requirements, minimum food requirements, ratios that we all have to meet. So if that's the case, we still must oppose this measure as a standalone bar for the first time in Virginia.
There are questions for Mr. Lisk?
Mr. Chairman.
Senator Cosgrove.
Mr. Lisk? That's not what I heard. Question for you, please.
Wait a minute.
Basically, you just said that
we have a question for Mr. Lisk.
Yeah. Basically, you just said that, this be the first, standalone bar because they don't have food and everything. What about breweries and wineries? Don't they sell their product with no food and alcohol ratio?
That is correct. They do, but they don't.
Then the question is, are they standalone bars as well?
Senator Cosgrove.
Well, frankly, they are, except they don't have mixed beverages. And whether it's right or wrong, the Commonwealth's policy is to treat mixed beverages in a very different, much more strict fashion. You can't go into a grocery store and buy liquor the way you can beer and wine.
Right.
Restaurants that serve beer and wine have no food ratio. Restaurants that serve liquor do. So we have a different policy for spirits.
Mr. Laureate, did you have a comment?
He
Mr. Chairman, very, very briefly, I'm Miles Lauria, representing the Downtown Business Group. I just want to associate myself with Mr. Lisk's comment.
Thank you very
Thank
much.
Mr. Chairman, while they're
Senator McDougal.
while they're talking,
Mr. Chairman,
Yep. Senator McDougal, yeah.
while they're talking, I very much enjoy being able to have a cigar every now and again, and I've been known to enjoy having a mixed beverage or non-mixed beverage, depending on whether you call ice a mixer, as well. But I do think that we've set up a system where a number of individuals throughout the Commonwealth have expended tremendous amount of personal resources to comply with our statutes, facilities that have a kitchen and the ability to smoke cigars, and they've built their business model on that. And when we change this, if this goes forward, those places will no longer be able to financially operate because you won't need to have a kitchen operation in order to have alcohol, mixed drinks, and cigars. So,
Mr. Chairman, can I interrupt Senator McDougal?
No, Mr. Chairman, I do think that this is a pretty substantive departure, and there will be some people that lose their entire investment as a result of passage of this. So,
Senator Reeves.
Mr. Chairman, if I could ask that this bill go by, we didn't have the right amendment on there that would address what Senator McDougal is exactly talking about. Somehow, between David and I, we had a miscommunication on what the actual amendment that Mr. Lisk, myself, and the cigar folks had agreed upon. So I'm not in good order on this
The previous chairman, I would tell you, was pretty strict on that, but this new chairman will see it your way. And
well, Mr. Chairman, I appreciate that, Mr. Chairman, because I don't think we're going to get out of here and have
coming back and seeing us next week on that bill.
We're going to have a meeting next week because we're not going to get out of here.
Okay,
So.
all right.
All right, Mr. Chairman, I'd like to pull up.
Yeah. Without objection.
We're going to have a meeting next week because we're not going to finish all the docket today, I'm afraid. Mr. Chairman, with that, I'd like to move to.
You get a little feedback here. There you go. What bill would you like now, Senator Reeves?
Senate Bill 484, Mr. Chairman. Mr. Chairman, last night, I'd been working on a substitute for Senate Bill 484, and you all should have gotten the substitute in your inbox at some point. It's about a 20-page substitute. And what that bill does, Mr. Chairman, or the substitute, if we can get that properly for us, I'd make the motion to move the substitute.
Been moved and seconded, the substitute be adopted. All those in favor say aye. Any opposed? Okay, the substitute's before us.
Mr. Chairman, for a number of years, when distillers started out, this is before my time, and Mr. Chairman, I'm not sure if you were here for this part of distillers becoming government stores. They operated as a government store. In other words, they had the ability to sell to people that came into their actual manufacturing facilities where they had distilled spirits. There's approximately 38 of these that the individual owners act as store owners for the Commonwealth. One of the challenges that ABC faces is having 38 of these stores. I think there's 7 pending trying to come into the system, of trying to get them on the new authority and trying to make sure they operate like the 300 plus other stores that are stores and strip malls that we see throughout the Commonwealth. But distillers tried to figure out a way that they could still sell their products, but under government control. What this bill does is actually think outside the box. And what you're going to hear is that the reality of this bill is that it's about swapping monies. And so if the committee will indulge me just for a second, I'd like David to kind of go through the logic of what we're trying to do in some of the changes to this bill and the substitute that you have before you. So, David, can you do that?
Mr. Chair, I think it'd be helpful for the committee members to start off with a little bit of background information. Originally, the law in Virginia was that ABC was in charge of selling all distilled spirits. Then in 2006, the General Assembly extended that privilege to distillers and basically did so by appointing them as fictitious agents of the board, thereby allowing them to sell distilled spirits at a store on their premises that was the fictitious government store. Through this process, basically, once a distiller manufactures their spirits, they'll transfer ownership of the spirits on paper to ABC, sell it to the consumer, send all of the money to ABC, and then ABC returns a portion of the money that's due to the distiller, which is basically the same amount that they would have gotten had they sold the product straight to ABC in the first place, plus a small commission. Under the bill, fundamentally, everything will stay the same. What they can sell, where they can sell, when they can sell it. Spirits will only be sold for off-premises consumption. The tasting and quantity limitations remain the same. All other rules that apply to government stores will also remain the same, such as hours on Sunday. The only real change relates to how the money changes hands. Instead of appointing these distillers as a fictitious agent of the board and funneling all of the money through ABC, essentially the distiller will buy this license that we've created in the bill and then sell the liquor in the same way that they're doing it now and just send ABC the portion of the money that's due to them, which is the excise tax, currently at 20%, and under the bill we've raised it to 30%. Currently, ABC is generating a revenue through this process of about $818,000. By raising the excise tax from 20 to 30%, will generate about $400,000 in new money. The license fees, just from the top third tier that we're creating in this new license, will generate about $170,000 more. So once you add in the other license fees, you're probably looking at a void of around $200,000 between our current system and what's proposed underneath this bill. I'd be happy to answer any other questions that the committee has.
So what we've done is we're trying to allow distillers no longer to have to work in an adversarial ownership type agreement with ABC. I know in speaking with ABC that there are some challenges to having stores that they don't truly own under this type of agreement. It would allow some flexibility finally to distillers under very controlled circumstances. They have to be a distiller, they have to produce it on site, those sort of things. And so you will hear an argument that this is privatization. Is it in that sense privatization? I'd say no, because it's not like we're opening stores everywhere. The reality is that the system is inefficient to ABC now. It's very difficult for them due to some of the different distillers and their ability to get some of the reporting done and some of those things. And it would also allow the distillers the opportunity for those who are entrepreneurs to actually feel like they own their business. And so I do have a witness here, Mr. Denver Riggleman, who owns Silverback, to speak to the committee briefly, Mr. Chairman.
Okay, let's hear from the witness, and then we'll hear from ABC, and then we'll hear from anyone who may support it and anyone who may be opposed. Welcome, Mr. Riggleman.
Thank you, sir. Thank you, Mr. Chairman, everybody here. I appreciate you hearing me out today. By the way, I just want to remind the chairman sitting right now that the Air Force actually leads Navy 20 to 15 in the Commanders' Cups over the last 40 to 50 years.
That's not helping your bill.
Also, just like to remind that the Navy and the Air Force allowed the Army to have one this year after 21 years. So I just want to remind people of that.
Really
so, yeah, I know that's not helping me very much. Thank you for having me today. Just like in football, you know, there's something, I played a little football myself. We talk about fair competition. That's something that distillers want in the Commonwealth. My wife and I came here back home. I was born and raised in Virginia. Came back to start a distillery and put $2.5 million in a Silverback distillery. There are actually distillers sitting in here today that put 10 times that amount in their distilleries as we go forward to try to build a distillery industry in Virginia. What we're asking on this bill, and I want to clear up something right now. I do not have an antagonistic relationship with ABC employees or people that have been completely transparent with me, but I am antagonistic towards some of the policies in ABC that doesn't allow us to be on a level playing field. We're okay with the two-tiered system in ABC and in Virginia. I've been dealing with it for some time. Right now, Silverback has done so well that we're willing to expand, but we're actually expanding into Pennsylvania. And some of those reasons in a liquor control board state, just like Virginia and Pennsylvania, They've lowered their commissions. They've actually freed up the ability to do business, where my $250,000 profit transfer to ABC this year would have been $52,000 in Pennsylvania. Also, as we go forward, we always wonder why we can't keep our own profits within our own distillery store. We are the only industry in Virginia that profit transfers our retail profits out of our store. Now, a lot of people told me, Denver, why didn't you do due diligence before you knew about this 46% that was going out of your store? And I'll tell you this, because when we started our store, our commissions were different. Our commissions were arbitrarily determined by the governor. When we started this, we actually had a tiered system up to 15% that we did our due diligence and our pro formas on. I don't know if you remember a couple years ago, Governor McAuliffe lowered our commission to 0% while we were in business. It was at that time that I realized that all the due diligence we did was sort of for naught. Because as a businessman, you're looking for an actual stable way of doing business in a business environment. And underneath a monopoly, that's very difficult if they can arbitrarily determine your commissions. So just like football, I'd rather have a free and fair playing field as we go forward. And I do not want to expand into Pennsylvania when I'm a Virginia boy born and bred. And my wife is a master distiller whose family goes back to the 17th century here. There's a lot of arguments. I think we made a lot of people nervous because competition can make people nervous. That's something distilleries are pretty used to. This is our thing in Virginia. I'm not going to tell you what my grandfather did because I don't want his name to be sullied, but we do like our liquor. But I do want to tell you this. As we move forward, I would love the chance to be able to have a retail store to sell in the state under a fair and level playing field, and also to eat cupcakes with liquor in a museum, because I think that's one of the coolest things of freedom. If I can eat cupcakes with silverback icing in a museum while smoking a cigar, I think Virginia becomes the #1 place for doing business in the Commonwealth, in the world, actually, for these types of industries. So thank you for your time. This is about freedom and competition. I appreciate your time, and thanks again. I'm available for any questions. Thank you, sir.
Thank you. The question from Mr. Riggleman. Okay. No, we have no questions. Thanks. Can we hear from the commissioner? You have a position on the bill, or where do you stand?
Mr. Chairman, Travis Hill of Virginia ABC. I don't know that I can describe it as a position as we go through it. I think I can tell you to go through, this bill would change the relationship between ABC and the distillery stores. Right now, we have operating agreements. They would no longer enter into those operating agreements with us. They would not be governed by our business practices. They would continue to remit taxes to us. I think in the bill, we would continue to set prices of all distilled spirits in our stores or in the distillery stores. And I don't think the distilleries would sell directly to licensees anymore because licensees in Virginia have to purchase from a government store. So that's my understanding of it. You know, a little bit on the current situation. It is in manual. We manually reconcile all the sales from our distilleries or from the distillery stores into our books. We do work with them on different business practices. They're all a little bit different. So we probably have one FTE, maybe a little bit more, working with these individuals through their business practices. So there's certainly some management issues going there. With all of these distillery bills this year, with commissions keeping markup, I also expressed to the members, revenue is our chief concern, and being able to transfer money into the general fund. I understand there's some revenue provisions in here. We haven't had a chance to sit down and really look at, other than back of the envelope stuff, what that transaction would be. But it certainly would have a revenue impact on us going forward, and we'd have to see if what the provisions in this bill have been put in, whether they would recover any of that lost profit or not. But that's.
I understand if the bill does move forward, it'll be referred to finance. But is there anyone else in support of the bill?
Mr. Chairman,
Senator
could I maybe ask Travis a question or two?
Sure.
Travis,
yes, sir.
Help me go through this process, but I'm looking at lines 34 through 39 on page 2. So if I'm reading this correctly, and that's why I'm asking you the question, is the holder of a distiller's retail license now may sell in closed containers for off-premises consumption spirits manufactured by them or manufactured for them or blended by the licensee on the licensed premises. Those are all ors, no ands there, is that correct?
Yes, sir.
Mr. Chairman?
Yes.
Just a question. So if you had a large distiller like a corporation like a Diageo that manufactures 50 brands, I don't know how many brands they had, they could manufacture one of those brands under this license and sell all the brands at their store under this license. Because it says or, not and. Is that accurate?
I think they would have to, those spirits would have to be manufactured on those premises or blended on those premises in order to be sold on those premises. That's how we would.
Mr. Chairman?
Senator McDougal.
I think if those said and, that might be the case, but they say or. It says manufactured by, or manufactured for, or blended on the licensed premises. So Mr. Chairman, if I'm hearing your intent,
Curtis,
your
did you?
intent is not to have those all as exclusive.
Travis, no reflection on you. A blast from the past has just stood up and might be able to help him right now.
I would say current interpretation is that in order for a distillery to sell something on their premises under the current arrangement, it has to be manufactured or blended on those premises. I don't know that that would change with this language, but I'd have to study it, but that would be my interpretation.
Curtis, did you have something?
Mr. Chairman, all I can give you is the history of that the piece about manufactured for was done for Mount Vernon because they weren't manufacturing it. A. Smith Bowman came over to Mount Vernon and made some liquor for them in the early days. So the intent was, and what we've always interpreted when I was there, like Travis just said, was that all of that activity had to happen on the licensed premises, whether it was manufactured by them or by somebody else for them. It had to be on the licensed premises. That was the intent of how we wrote it.
And Curtis knows because he issued George Washington his first.
I did.
David, do you have a comment?
Senator McDougal.
Mr. Chairman, if that's the intent, I think that those descriptors, I'm not sure that I read that, or I think another crafty attorney like Senator Servell might say that on licensed premises does not apply to all the others because it's or. So if somebody wanted to come in and say, well, this was manufactured for me and it doesn't have to be on my premises and now they're a retail store. So if the intention's not to do that, I think the words need to be different.
All right. That's the intention, is not to do that, is to keep with the status quo. So David, do you have a?
Yeah, Mr. Chair, so the language that Senator McDougal is referring to tracks current language in the code. Like Mr. Colburn was explaining, the provision was set up to account for one specific place that wasn't actually manufacturing their spirits on the premises. Everyone else underneath this language, which is the same that exists in code now, they have to make their spirits on the licensed premises. That's how it's been interpreted by ABC, and that's how it's enforced. If we did change the language, it may affect the ability of the facility who is currently using this provision to sell their distilled spirits on the licensed premises.
Mr. Chairman.
Senator.
Well, thank you. Ben, what you were saying, let's take it from a non-lawyer's point of view. So if this was in court, I'm gonna hire Scott Serbia because his intent and what he would say. So my question is, if he was my lawyer, then it could be either or. So I'm trying to understand, what is it? You could say intent, but 25 years from now, we're not here. Somebody else can be here. They can say their intent might be different. So can we get a solid answer? Intent
Mr. Chairman, in response to Senator Sproul, what I found with attorneys is they all have a different interpretation of just about every word except for shall and may. At least
Scott Serbia too?
I've learned that here. So with all due respect to Senator McDougal, I don't know. I have to listen to the people that are doing this. We're not changing the bill, the language of that bill that's currently in effect. So the or has been there for a very long time. And, because we're doing some other changes in this bill to allow some freedoms, Could it probably, somebody bring it up? I'm sure somebody will find a smart attorney to bring any kind of suit they want on any bill that we ever pass. So, Senator Spruill, I don't know what to make of it. I think if we change the bill, then that could have significant consequences counter to what we're trying to actually do. So I would not view that as a friendly amendment if he was making one at this point.
Okay, not a friendly amendment. I can see that Senator Sturvell and Senator McDougal are working on a new potential business prospects. I think there's some opposition to this bill, Senator Reeves, and we might want to hear from them.
Good morning, Mr. Chairman. Phil Boykin with the Virginia Beer Wholesalers Association. I had not planned to speak on this bill, but based on the description of the substitute provided, it raises serious concerns for us. Basically, you guys have heard this before. Previous governor proposed something very similar, and that was rejected. This would be privatization. It's direct sales. You're privatizing the distilleries, and so we have to look at it some more. But we would strongly oppose the substitute as it was described. Thank you.
Thank you, Senator Boykin. Mr. Lisk.
Mr. Chairman, members of the committee, I'm here on this bill testifying on behalf of Diageo North America, one of the largest liquor producers in the country, in the nation, the world. And I'm just saying the language for the first time. But I would just caution you that Virginia has given special privileges to its distillers because the distillers have been an agent of the Commonwealth. They've been an agent of the ABC Board, and therefore they're not subject to concerns about Commerce Clause restrictions. Under this bill, as I read it, the distillers no longer are agents of the Commonwealth. They are now businesses selling distilled spirits at retail. So you now have Commerce Clause concerns. I think if you do not allow Brown-Forman, makers of Jack Daniels, Bacardi, Diageo to have the equal ability to set up stores in Virginia to sell their products without the markup, but with the increased excise tax, in fact, you may invite litigation. Certainly, we think that distillers should be treated fairly. There should be equal competition, and to the extent that you're going to allow Virginia distillers at private businesses to sell their spirits, we should have the same opportunity to do so. Thank you.
Thank you.
Mr. Chairman, Chuck Duvall with Virginia Wine Wholesalers. I don't know that we're for it or against it because really the first time I've seen it and I'm not sure I totally understand it. But to Mr. List's comments, I'm not a lawyer, but having financed a lot of lawyers on the wine side on issues very similar to this, I think you better tread very carefully because if you're opening the door on privatization, what Mr. List said, you're not going to find just the Virginia distillers at the table. You're going to find the out-of-state guys who are huge saying, we want the same treatment. And does that kill the goose that's laying the golden egg for Senator Hanger's committee and those others that serve on the Finance Committee? So I think you better study this thing long and very carefully because you're treading on some pretty thin ice here.
Thank you. Mr. Laureate.
Mr. Chairman, members of the committee, Miles Loria for the Downtown Business Group. I think I'm in the same posture as the previous speakers. We're just not quite sure whether we like it or whether we don't, but we do have a lot of questions. So we would urge you to tread very, very carefully. Thank you, sir.
Mr. Chairman, can I wrap up?
Senator Reeves.
So you've heard the arguments, the same arguments we hear every time we come in here to try to do something. No one wants to allow the freedom for these individuals who set these stores up. Listen, Diageo would like to come here and set up a distillery and spend the money and spend $2 million to do a distillery. Please come. Jack Daniels, please come. Maker's Mark, please bring that investment. I'd love to grow distilleries here. So there's no unfair advantage for them to move and come here. Now, if they want to come here just to sell and not set up a distillery, then they couldn't do this. We're talking about infrastructure. We're talking about jobs. We're talking about growing the distillery business and trying to get states like Kentucky and Tennessee from cleaning our bags. That's what we're talking about here. We're not talking about privatization of 350 stores. That's malarkey. We're talking about 38 distillers who are government agents who want to be government agents, and I don't blame them. I've worked out a pretty good idea about how we can backfill the revenues that the state's probably going to wind up taking into shorts to almost $600 and some odd thousand. So I've got a $200,000 deficit I got to figure out. But we've done that through increasing the excise tax by 10% and adjusting the fees. We can adjust the fees even more. But you've heard from guys like Mr. Riggleman, and there are a bunch of those guys that have invested time and all these other things in trying to grow their business. It's the only business that we put a hammer on. We do this in the wine and beer. I don't know why the wine and beer guys are up here complaining. You can own a winery and have 7 retail stores without any manufacturing happening in those stores. 0. We're giving these guys nothing. And we're going to lose millions of dollars of investments of distilleries because we're scared of our shadow? Give me a break. I'm a small business owner. I live in a franchise agreement. They're under a franchise agreement with the government right now. We have an opportunity to make a statement, to tell these people that they can operate their business as they'd like to. You've heard from ABC, there are some challenges with running 38 stores where they're not standard retail stores. Nothing changes here. They're still having to do all those things. It's a matter of changing money and the ability for these folks to actually have their livelihood determined by them and not under the guise of ABC. They still have to comply with all the legal stuff. They can still only serve a certain amount of spirits. They have to stay open according to the stores in which they're governed currently. This isn't a radical move. It doesn't need to be studied. It'll work. Mr. Chairman, that's the bill.
Thank you, Senator Reeves. The substitute is before us.
Mr. Chairman, I'd like to make the motion to adopt the substitute.
We have adopted the substitute.
Well,
The
then
substitute's
we
before us.
refer to finance.
Second.
Okay, it's been moved and seconded that the bill, Senate Bill
Mr.
484, Amendment in Nature Substitute, be reported and referred to finance. Any discussion?
Question for the patron.
Senator McDougal.
Mr. Chairman, I very much respect what Senator Reeves is trying to do. I am not yet convinced that the words do exactly what he's articulated his desire to do, and so I'm going to throw up abstention on this to make sure it's on the regular calendar and we keep reviewing it. I do think it's important for us to look at it and make sure that strategically the words are doing what conceptually we hope to do going forward.
Senator Chafin, did you have a comment? No, I didn't. Okay, Senator Sproul.
Mr. Chairman, I had a no down on this one, but I'm listening to those who are in the business come in and they are not sure, and they are in the business, and they are in the business, they're not sure, and I'm not in the business, so I'm gonna give you the benefit of the doubt. I'm gonna vote yes.
Okay.
Thanks,
Senator Favola.
Is it possible to maybe pass this by for a week so we can work on the language, make sure that the language says what the patron thinks it should say, or what the patron intends for the language to say, and perhaps have a more collaborative conversation with the folks who have opposition to it? I feel uncomfortable saying I support this, and even though we'd be re-referring it to finance. So just my 2 cents.
Comments taken. Senator McFadden.
Mr. Chairman, a question for the patron. You have a number of bills that are addressing this issue, and one of which directly with Mr. Riggleman's comment on the commission. Is that correct?
I do.
That seems to be the underlying issue. This bill doesn't get at what the original complaint was. I'd offer an alternate motion to PBI, because I'd like to frankly hear the other bills, which I think directly deal with the business model case, which I think is valid and this committee should consider and discuss.
Okay, there's a substitute motion to pass by indefinitely. So it's been moved and seconded that the bill be passed by indefinitely. Any more discussion? Clerk, open the roll.
So the motion is, Mr. Chairman, to PBI.
Ayes 6, noes 8.
Okay, that motion fails. The primary motion is before us. That motion is to report and re-refer to finance. Clerk, open the roll.
Ayes 7, noes 6.
Ayes 7, no 6. The bill has been reported and re-referred to the Committee on Finance. Senator Reeves, it is now about 22 minutes before
Mr. Chairman,
starts.
I don't think we can get done, and I'd make the motion that the committee would rise.
You don't need to make that. Chairman can do that, but you're the chairman, but I got the gavel. Committee will rise.